Okay. Hi, good afternoon, everyone. My name is Arshi Pal. I'm an attorney with Lippman Crooks, and I'm very excited to be here with you today for our lunch with Lippman Crooks. Today, we will be discussing the remedies available under the IDEA, which is the Individuals with Disabilities Education Act. And this is a federal statute that is that's available to individuals with disabilities to ensure that they have a right to a meaningful education. So the way that we would actually get to the remedy stage, which means, you know, what you would win if you had an actual case against the Department of Education, is first we have to allege that the Department of Education failed to provide what's called a free, appropriate public education for a student with a disability. And that can be done in various ways. You can file a due process complaint or a request for an impartial hearing. And you would have, you know, and this is kind of an administrative hearing. It's an administrative process. So we would be in front of what's called an impartial hearing officer, or IHO for short. And as I mentioned, the due process complaint is where you're going to be listing, you know, first of all, we want to ensure that we have the student's name, his or her date of birth, and his or her ID number. If we're in New York City, we want to have our New York City ID number listed on the complaint. Additionally, we want to have the student's address and where they attend school. But the focus of today's discussion is actually one of the last parts of the complaint, which is our relief requested. And what we want the impartial hearing officer or the judge, you can compare the impartial hearing officer to the judge of the case, what we want him or her to award us. And under the IDEA, I want to make it very clear, because a lot of parents reach out to us and they say, well, I want to sue the school district and I want money damages. Unfortunately, under the IDEA, money damages or punitive damages, which means, you know, you want to punish the school district for their bad deeds or their failure to provide a free, appropriate public education. Unfortunately, that's not available under the Individuals with Disabilities Education Act. However, there are two other statutes, the ADA, Americans with Disabilities Act, and or Section 504 of the Rehabilitation Act, which actually do offer money damages in certain situations. So aside from putting that aside, there's a caveat. Under the IDEA, you can get money damage, tuition reimbursement. So it's technically, you are still receiving money, but it's not punitive. It's not to punish the school district. It's more so to help the student with disability, you know, if it's found that private tuition is necessary. So I'll quickly list the various reliefs that we could potentially seek, but I also want to emphasize that under the IDEA, the impartial hearing officer has broad authority. So there's actually, you know, most of the time in our due process complaints, we always add that very last section that says any relief that the IHO deems appropriate. They already have that, but it's kind of, you know, easier for them to use that if they find, you know, there's something that we maybe didn't realize that we needed, and that based on the review of the reports or something like that, the IHO feels that it's necessary, you know, maybe another evaluation or something of the sort. I actually had that happen in one of my cases where I wasn't aware that the student that I was representing actually had a vision impairment. It was a very sophisticated diagnosis that I had never encountered. The mother had no idea, but interestingly, the IHO's daughter actually had a similar impairment. So she awarded for our student a specialized ophthalmology evaluation, which actually helped us better understand why the student was having so much difficulty with reading and writing, and actually understanding what she was reading and writing. However, the typical, so to speak, as I mentioned, there are other things that we could request, but the typical reliefs we could request are tuition reimbursement. And I'll get into how to support those and how we should be, presenting them in front of the IHO. But we have tuition reimbursement, we have independent evaluations or reimbursement for evaluations. We have compensatory tutoring, compensatory related services. We can ask for a new individualized education program. We can also ask for prospective relief. So, maybe we can ask the IHO to grant or award, let's say 5 times of speech per week moving forward. We can also additionally ask the impartial hearing officer to award transportation services. So we had a case where an individual, he was medically fragile, so he actually could not take either public transportation or even yellow bus. The district does provide school buses for individuals with disabilities. However, he couldn't. He needed a very small one-to-one kind of thing. So we actually were able to get reimbursement for Uber rides for the student to go to his private placement and back home. There was a limit, there's always things that the IHOs will look at, but you always have to present your case, and you always have to make sure that you're documenting everything, because if you do end up in an impartial hearing situation, all those documents, all those notes can only help you in the future. So going back to the tuition reimbursement, which is one of the most, I wouldn't say it's difficult, but it is a bit of a higher threshold than some of the other reliefs that we will be discussing. And so there was actually a case called Burlington. So there were 2 cases, Burlington and Carter, that carved out a 3-prong test that we must pass and able to get tuition reimbursement. So the first prong is that the school district, that the IHO has to find that the school district failed to provide a free, appropriate public education to the student with a disability. So, that can include things like procedural violations, like the school district didn't provide adequate notice to the parent of the IEP meeting, or the school district failed to provide a functional behavior assessment, or the school district failed to appropriately evaluate the student. And then if there is found that there's a procedural violation, we also have to go the second step of proving that it actually affected the educational benefit that the student could have received. And then if there's the other thing that we can do to prove that there was a denial of FAPE is a substantive violation. So substantially, the IEP was inappropriate, it did not provide enough supports, or the IEP was not being implemented. All the services that were listed that the student with a disability should have received in the individualized education program, either the public school wasn't able to offer those, or the public school wasn't offering it appropriately. Like maybe, for example, the student was supposed to be receiving counseling services for an hour for 3 times a week, but the school, because of their schedule, was only able to provide it for a half an hour 2 times a week. Well, that would be an example of a substantive violation. So once we prove the prong 1, we move on to prong 2. So let's say that the impartial hearing officer finds that yes, the school district indeed did fail to provide a free, appropriate public education to the student with a disability. Then the burden shifts to the parent to prove that the private school that they're interested in, or the one that they want tuition reimbursement for, is appropriate. So that particular private school can help the student make progress. They can provide a FAPE. There will be educational benefits to the student for attending that private placement. So let's say that we pass prong 1, prong 2. Prong 3 is a very broad prong, which is equity support reimbursement. So various things over there we have seen, in courts, even impartial hearing officers. Sometimes, let's say that we pass prong 1, prong 2, and we find that yes, this parent should get reimbursement. Sometimes at prong 3, the impartial hearing officer can reduce the amount of reimbursement. So maybe if, let's just say that the tuition for a month of a private school was like, I don't know, $30,000. If we get to prong 3 and the school district can, prove that the parent did not cooperate with the school district, like let's say, for example, one of our issues was that the student wasn't appropriately evaluated. Well, sometimes it's really hard to tell parents that you have to cooperate with the school district. Sometimes you get, so to speak, a bad taste in your mouth and you don't trust the school district. It later on, and you don't make your child available for these evaluations, it may hurt you later on if you do go to a impartial hearing. So I did see sometimes in either cases or, discussions that I've had with parents, if the parent doesn't cooperate or if they don't make this student available for either services and or evaluations, the IHO may reduce how much reimbursement you'll get. So like I mentioned, that example, if it's 30,000, maybe they'll reduce it 10,000 because you failed to cooperate. I mean, there's no real formula. It's really under IHO discretion on how much they can reduce it. Additionally, under equities, although this is part of the 3-pronged test of tuition reimbursement under Carter and Burlington, I've seen equities take a toll on other cases as well. So moving along to another type of remedy under the IDEA, compensatory services or compensatory tutoring. So an IHO can award either or compensatory tutoring, such as, any specialized kind of Orton Gillingham or any Wilson program, any Linda Mubel, for a student with a disability if there's been a substantial deprivation of FAPE for a long period of time, a gross violation of FAPE. And the whole point of compensatory services or compensatory education is to help the student make up for the fact that they didn't receive it in the past. It's to compensate them. And under that kind of approach, the way that we would be able to show that the student is entitled is either we can show that they were, for example, if we were doing related services, that they were mandated to receive physical therapy and or occupational therapy twice a week for 30 minutes each session, but it wasn't provided for the last 2 years. So that's a relatively easier way to prove that there was that the student missed out on services. However, something a little bit more intricate is that maybe the student was receiving the services where the goals were inappropriate, or maybe the student was receiving the services but they were in a group of 4, but that was too large because the student had attention issues, so maybe he needed a one-to-one approach for those services. So that's where you have to get a little bit more creative, or you have a bit of a higher threshold. So in that kind of a scenario, when we're trying to get a parent or a student compensatory related services, we might have to also ask for maybe a neuropsychological evaluation or a psychoeducational. We might have to ask for a speech language therapy evaluation, depending on which service you're trying to get or you feel that your student needs. You may also have to get a physical therapy, occupational therapy, various types of evaluations. So in that, sometimes the evaluators or the examiners or the psychologists will say, well, the student is severely lacking in their communication skills or something like that. That helps the IHO, that helps you as a parent kind of show the IHO that, listen, the student needs this kind of a compensatory related service. But what we want to be careful of is that we don't want to ask, because there was a recent case, Reed, which is in the District of Columbia, where there were 2 approaches to how they could, how an IHO can award related services, compensatory related services. And in that case, the IHO used what's called the quantitative approach, which is they tried to do hour for hour. So as I was mentioning, maybe the student was supposed to be getting counseling twice a week for half an hour each session, and he missed out on a whole school year's worth of counseling. So let's do the math. That's about an hour a week, and there's about 40 hours in a school year, so that's 40 hours. The court in Reed actually said that that's not how you should be calculating it. In that case, they actually, I think, awarded the student about 803 hours of tutoring. It was an hour for everything he missed. So the ones that, especially here in New York City, we have an IHO who actually, you know, has this in his introduction, that he goes over the quantitative and the qualitative. So now there's I wouldn't say it's a shift, but it's a focus on the qualitative approach on compensatory related services. So the whole point of the qualitative would be, how do we get the student in a situation where he would have been had he received the appropriate services? So it's a little bit of a difficult kind of, you have to analyze, you know, we have to do the math, we have to figure it out. It's sometimes you could even go, sometimes the IHO can even give you more than 40 hours because it's deemed that in order to make progress, the student actually needed 2 hours a week. That 1 hour a week wasn't going to help him anyways. It could be that maybe the student is going to be able to work faster, so maybe it'll be 20 hours of compensatory related services. And then, as I was mentioning, compensatory tutoring, I kind of put them hand in hand because they're both compensatory education and tutoring. But if we were trying to get compensatory tutoring, I would recommend maybe we would get like an academic evaluation. So there are various tutoring agencies out there. And, you know, usually they do their own baseline assessments anyways to try to see where is the student struggling, what kind of approach would we use for this person. So I have taken those academic evaluations to an impartial hearing officer and showed, like, look, the student is in 9th grade, but unfortunately they're reading and writing at a 1st grade level. So then we have that individual who did that assessment testify at the hearing to describe what were the different instruments or the assessment tools that they used, and how many hours do they recommend based on their experience that the student requires in order to make meaningful progress in their academics. And usually, you know, that's a pretty relative approach. I also have a neuropsychologist that I've worked with for many years, and he actually found, based on scientific research, that a student with a disability, obviously it's case by case, but based on their research, that about 100 hours are required of academic tutoring to try to go up a level in reading and or math. Obviously, every individual with a disability is different, but based on their research, I don't have that. Unfortunately, I don't have the name of that research study, but I did, you know, so we were able to use that also in order to get those tutoring hours for a student. But as I was mentioning in our first relief in the tuition reimbursement, the equities can actually end up harming if, you know, or taking away relief. So just recently I had a case where I was trying to get both ABA services. It was a student with autism, and I was trying to get him both ABA services and compensatory tutoring. And it turns out that the ABA agency that did the assessment recommended about, I believe it was 20 hours a week of ABA. And then the tutoring agency with their academic evaluation ended up recommending about, I think, 4 hours a week of tutoring. Additionally, we requested, and we actually had solid proof that the student did not receive his related services. So we ended up having a request of that, all of that as well. And here the school actually, this district actually, you know, realized that this student was being underserved. You know, this was one of the rare cases where the school district was working with us and was saying to the impartial hearing officer, like, yes, you know, the student requires all of these things. They require the ABA, the compensatory ABA services. They require the compensatory tutoring. They require the compensatory counseling and the compensatory occupational therapy. However, there's not enough time, or there's not enough hours in the week for the student to receive all of these things. So putting equities, thinking about the equities in this case, although I had requested 500 hours of ABA and 500 hours of tutoring, the IHO actually awarded a little bit less, because the IHO said that it doesn't make sense to give all of this to the student. It might harm him and overwhelm him rather than helping him. So then that was a case where we actually had to, we actually thought about it, and it was actually true that, you know, the student has such severe needs that it was actually better that the IHO gave everything we wanted, but he just didn't give as much as we had requested. And then one of the next forms of relief that we could request, as I mentioned, is evaluations. So, you know, as I mentioned, that sometimes school districts fail to conduct timely or appropriate evaluations. And during this pandemic, we actually realized that a lot of school districts, especially in New York City, didn't have the capabilities to conduct evaluations. So we found that teachers in Brooklyn were completing 40-page reports in lieu of actual psychoeducationals and or neuropsychs. That is a big no-no, because we want someone who has a little bit, we want a psychologist to look at where the student is. We want to look at their social emotional functioning. We want to see their academics. We want to see if they have any behaviors that impede upon their learning. And especially if the student is doing remote learning, that just adds another layer of complications, or like, you know, you can't really observe the student. So that causes another issue. So in that kind of a scenario, we actually had 2 or 3 cases that we took to impartial hearing because we did not find that those evaluations were appropriate. And then we requested at the impartial hearing that the impartial hearing officer award a neuropsychological, which is a very comprehensive, it's actually a little bit higher or a little bit more involved in a psychoeducational, that goes into a little bit of the cognitive functioning of a student. We also requested speech language therapy evaluations and occupational therapy evaluations for that particular child. But then we found, as I mentioned, that the school district did not have the capabilities. A lot of providers either retired or a lot of them are working from home. So what we said to the impartial hearing officer was that we have an agency in mind that's able to provide these, following all the CDC, you know, requirements with the pandemic, making sure that everything is safe. And the impartial hearing officer awarded the neuropsychological and the rest of the evaluations. Another form of relief that we can request, a very complicated one, I should say, is extended eligibility. So students with disabilities are eligible for educational services from the age of 5 years old to 21 or until they graduate high school. So I had a case where we had a student with a disability and she was attending a NPS, what's called a non-public school. And that was actually through a CBST deferral, which is a central-based support team deferral, where the school district themselves found that they couldn't help the student in the public school and she needed a specialized private placement. So they had placed her there. It came time, the student actually was in high school, and when it was her 12th grade year, the first time that she attended 12th grade, it was found that she was turning 18 soon and that she was not ready for graduation. So they decided that she would be retained, and the parent agreed that her levels were not there yet for independent living and or life after high school. Then when she repeated her second year, and they said everybody agreed at that meeting in her first time that she attended 12th grade that she would stay there for another 2 years. So then come September, she's retained and she's doing 12th grade all over again, as was decided by everyone. And she didn't pass all of her regions. She did not meet the requirements to obtain a diploma. So she believes in her mind, and the parent believes in her mind that, you know, she's going to be attending the same private school in September. Well, come April, they're told that the student is ready for graduation. And the parent vehemently opposed it. She said, my child is not ready for this. And you know, they went back and forth. They had several meetings, and there were no real solution. There was no resolution. So it's like June, and it's the last day of school, and the parent reaches out to us. And we had to, you know, literally get up and work on it right away, because as I mentioned, that you're only eligible until you either you're eligible for IDEA supports and services until either you graduate and or you turn 21 years old of age. Technically, they told her on the last day of school, you've graduated. No, they did not give her a diploma. She did not walk in her graduation ceremony. She didn't ever receive her transcript. So we come in as her attorneys, and we file right away a due process complaint, and we invoke what's called pendency. So while your case is being heard by an impartial hearing officer and or it's being reviewed by anyone, you have the entitlement to pendency, which is the last agreed upon IEP. So here, we actually said that she should remain in her private school until this whole issue is settled. And as we continued going on in the hearing, we requested, you know, we did Recourse request, we requested the diploma, we requested, and we had filed this literally in June, I believe. So when we finally received the diploma, it was August, and it was signed in August. So it was a very technical kind of thing, but we said that when we filed for this impartial hearing, she had technically not graduated because the diploma said August. Additionally, we had ample copies of communications of the parent, and even the meeting that had happened the years prior stating that the student would remain at the private school for another 2 years. We showed that she didn't, pass all of her regions. She wasn't ready. We had various notes, progress notes saying that she wasn't making progress. So we actually were able to get her what's called extended eligibility. She got another year of high school in, even though they had technically graduated her. We had another student, the one that I mentioned about the one who had the Uber rides. He also, although he had technically aged out and wasn't eligible anymore, we were able to show that there was such a severe deprivation to him that he was not in school for 2 years due to his disability. There was no real outreach from the school district, and we were able to get him extended eligibility as well. Another thing, I'm sorry, I was just looking at the questions. Another remedy that we can get under the IDEA is prospective relief. So occasionally in our due process complaints, we request that the IHO order a new IEP, or we request that the IHO defer to the CBSE, that the school district must defer to the CBSE, or if we have a particular prospective relief can be a particular private school. So we could ask the IHO to order the school district to place the student in a particular private school if we can prove that it's appropriate. Additionally, other prospective reliefs, as I mentioned before, we received an ABA assessment that stated that the student required at least 15 to 30 hours a week. So we were able to present that to the IHO, who awarded that specific relief, that the school district should fund about 15 hours of ABA services, either in the home or in the school, for the student to help them make progress with regard to their behaviors. And then I mentioned that we can get transportation. So sometimes when we ask for the compensatory tutoring, we also ask for either Metro cards or some form of transportation to the tutoring agency, or even if the student is going to a private school, Metro cards to the private school. Excuse me. And then additionally, I wanted to mention that, as I mentioned before, that the IHO can award any relief that they find appropriate. Something that we like to add as an attorney, you as a parent, and if you win at the impartial hearing level, or if you win and at the SRO level or at the district court level, you can get your attorney's fees paid by the school district. That's the fee shifting part of the IDEA. And but I do want to note that the IHO does not have authority over that. So although you may be entitled to attorney's fees, don't expect the IHO to grant that in an impartial hearing decision. Additionally, I wanted to mention, let me just look at my notes. Did I miss anything? That's it. But yes, let's open up the floor for any questions. Does the school district have a duty to tell the parents their eligible student may, if appropriate, receive services until age 21? Well, actually, I would say that the school district has the duty to provide you with your procedural rights document. And in that procedural rights document, that should actually have that information listed there. Unfortunately, students with parents usually become overwhelmed. It's a large document. Sometimes there's legalese listed in it. So that's how the parents miss out on that information. But if usually a school counselor or a school psychologist, if they're noticing that the student with the disability is not ready, they should. But do they always? No, they don't. Notify the parent that the student is eligible to stay in school till 21. I will note though that, when prior to the student's graduation, there must be a meeting held in November to talk a little bit about the transition planning, life after high school, things like that. So let's say the student is 18 and we're having that graduation meeting. That can be another opportunity for everyone in that meeting, which should include the parent, to talk about, I don't think that the student is ready, or the student is still struggling with X, Y, and Z skills. And that would be the opportunity for the school psychologist and or counselor to mention that, maybe the student should be retained, maybe they shouldn't graduate. But like I said, although in a perfect world, that's where it would happen, sometimes school districts don't inform you outright. Let me just read this other question. We placed our child in a specialized boarding high school and we believe he is doing very well, both academically and socially. When we ask for, another question pops up. When we ask for reimbursement, how is the decision made as to whether or not the parental placement is eligible for reimbursement? Is it a we say versus they say situation? So this is the tuition reimbursement three-pronged test that I was mentioning earlier. We have to prove, if we were to take this to an impartial hearing, we would have to prove that the school district failed to provide a free appropriate public education. So I'm not really sure the specifics of this case, but let's say your child was in the public school and they provided him an IEP and the IEP was inappropriate. So that would be one way to show that they failed to provide a free appropriate public education. Then after that, you can also show that, maybe the IEP was mandating certain things, but the public school offered couldn't implement those things. Then we're going to prong 2, where we would show that this particular private placement is able to address all of the different needs that the student has. So let's say the student needs ABA support throughout the classroom while he or she is receiving the academic portion, or maybe the student needs a one-to-one paraprofessional. We have to show that the school is meeting the student's needs. We can show that the student was making is making progress in the private placement. We can show that maybe he or she entered at reading at a level 2 and now they're reading at a level 5. 5th grade level. I'm sorry, we were reading at a 2nd grade level and now they're at a 5th grade level. Or maybe they entered and they had specific behaviors and now there's a significant reduction in those behaviors. And this is also a situation maybe you might benefit from having a a neuropsychological or maybe a private psychological evaluation showing that this particular child has all of these needs, and this particular placement is able to provide it. You would also get letters, and or you can have the providers from that private school testify at the hearing, talking about the different strategies that they're using with the child and that's helping him or her make progress. I hope that was helpful, but if you have any further questions, feel free to email me or call me later on. We can further discuss. Can you explain the due process rights around unilateral changes made by the school district to an IEP outside of Csc meeting without parental consent? Are there any recommendations for mediation before due process? Sure. So I mentioned a little bit about, I may have mentioned a little bit about parental input, or, you know, the collaboration between the CSC and the parents are a major part of the framework of the IDEA. So if there has been a significant change without your consent and or notification, that actually is a huge ground for bringing an impartial hearing. But, you know, sometimes clerical errors happen, things like that happen. Depending on your relationship with the school district, you may want to reach out to the school psychologist or, you know, the CSC team, explaining that either I don't agree, I don't fully understand what this means. Can we have either a IEP reconvene? Can we have a new IEP meeting? Or you don't think that it's appropriate, you know, maybe you want an evaluation, things like that. So there definitely is, you know, room for discussion, room for communication. Sometimes, unfortunately, we find by the time the parent has come to us, they've exhausted all of those types of things. And the school district is kind of putting up a wall. And at that point, sometimes the due process hearing is very necessary. Is there, similarly to last year, rule that exiting students 21 years old could stay another year if the student was mostly remote and couldn't do the transition activity? So this is actually, you know, as you know, it's a very, very new area because nobody ever knew about the pandemic. Nothing like this ever happened before. I can say there actually was a case in Connecticut that recently, such a situation exactly on point with what you're mentioning. It was a student who was 21 years old, actually got extended eligibility until 22, so they could finish up their you know, academics, their transition planning, their vocational skills, things like that. So I have actually recently seen that happen in a Connecticut case. New York, I know that the IHOs are being very flexible, so they're awarding things like compensatory tutoring or compensatory services, and even after the student with a disability graduates. So it's in a way extended eligibility, but it's not always the case. It's everything in these kind of hearings is very case specific. So they're going to look at a lot of different things, but I have seen that happen. So, you know, this is a very interesting question here. Can we request a mediation for tuition reimbursement? You probably can, but I would actually, I've seen where we've had clients before they've come to us, parents that actually attended mediation meetings with the school district. And, you know, they've sat there for 3-4 hours trying to work through these issues and they weren't able to, or they may have come up with a agreement, but the school district didn't implement it. And something to note that with the mediation agreement, you would actually have to go to federal court to get it enforced. So just be aware, it could work. I don't really know what your situation is. It could work, but even if you end up getting an agreement, sometimes they don't implement it, especially if you're working with the city DOE. They have a lot of backlogs right now. They have a lot going on. So, you know, you really want to think about those things, because if you get an agreement, you may have to eventually go to federal court to get it enforced. I'm not 100% sure regarding the attorney's fees for mediation. I can definitely look into that. You can feel free to reach out to us, but that's very very case specific, and I don't really think I've seen that happen in terms of mediation attorneys' fees. So in terms of who decides, I got a question directly to me, who decides that an IEP is appropriate? They believe it is co-teach only. We disagreed. He needs a small class for his tutors and therapists. So, you know, that's a typical, unfortunately, a typical situation where the school district is pushing, you know, maybe something less restrictive, and the parent and or other providers are saying the student needs something a little bit more either specialized, more structured, a smaller environment. Over there, this is a, you know, if you're unable to resolve this within the school district level, this is maybe a good time for an impartial hearing. And, you know, you may want to have progress reports showing that your student isn't making progress in ICT. You want to have those providers write notes in terms of, you know, he or she is struggling in this ICT. Maybe he or she has an attention disorder, or maybe he or she is unable to focus, or maybe he or she needs a little bit more one-to-one support. Have them write a letter, have them write notes, take progress notes. This might be another scenario in which you want to get either psychoeducational or neuropsychological, where the psychologist can actually make a recommendation, or you know, do a thorough review of the records and or the cognitive functioning of the student, and discuss what would be an appropriate setting for that particular child. So there's a very interesting question here. What recourse does the student have if the CSE refuses to allow them to attend the IEP meeting once they are of sufficient age? That in itself could be a reason for an impartial hearing. Well, actually, let me backtrack and have a caveat. It really depends on the functionality of the student. So let's say that the student isn't able to fully participate in terms of they wouldn't really understand what's going on in that meeting. You know, we do have some individuals with disabilities that are very high functioning and they can attend a meeting and they can put their input. I would 100% push for that. However, there are other individuals that are, you know, a little bit more lower functioning. Having them at a meeting, even though they're 18 or, you know, 16 or 18 or 17, it wouldn't be beneficial. However, if it's an individual who is higher functioning, who's able to provide their input, who's able to explain whether or not they find, let's say, for example, the occupational therapy, or maybe they find the counseling, maybe they don't find it appropriate, or maybe they find it, oh, I think it's helping me, but I need a little bit more. That's a very important thing that the CSE should discuss. So if you're finding that the CSE is not allowing the student, and they have that, you know, ability to appreciate the consequences of that, you know, the decision-making process, they can participate meaningfully, that might be a reason that you would want to bring an impartial hearing. Because although I keep saying parental input is very important, so is the student's input if he or she is able to meaningfully participate. Sorry. During the emergency period, if a child was not able to fully benefit from remote related services instruction, but frequency of the related service delivery was in accordance to the IEP, is that child eligible for compensatory services? If the student has been enrolled in a private approved program and additional compensatory services are requested by the parent, is the private program responsible for providing compensatory services in addition to meeting the IEP? Okay, so that's a lot. Give me 1 second to process it. I'll actually split it up, because this is a very common question that we're currently receiving. During the pandemic, a lot of students with disabilities weren't able to fully appropriately participate in the remote learning platform. We actually have seen impartial hearing officers, pursuant to the U.S. Department of Education guidance, provide compensatory either education and or compensatory related services in that situation to help the student make progress. So that may be, if you know you're trying to get related services even though the school district was providing it, we can show that, listen, the student had attentional difficulties. They weren't able to adequately participate. We can even have this, have the school district teachers kind of either testify, or we can have them say, we want progress reports of the student while they were receiving remote instruction. That in itself could be enough to show that the student requires compensatory related services and or tutoring. But like I said, I need to have a little bit more information on the particulars of the case. So feel free, if you want, later on we can discuss this, email me or give me a call. Yes, so actually, yes and no. Just let me read the question first. I get a little excited. So how do you ask for compensatory services during COVID? Do you have to file due process? So the US DOE guidance that I was mentioning actually allows and kind of gives the CSC authority to provide compensatory services for a student that they found either wasn't making progress with the remote services, and or they found that the school actually wasn't able to provide them with the remote services. So the CSC at the IEP team, the CSC could actually provide it themselves under that guidance. But unfortunately, we've been attending a lot of IEP meetings lately where the school psychologist either just doesn't feel comfortable, or they just, adamantly refuse to do it. So in that kind of a situation, you can file for a due process complaint. You can file a due process complaint for a hearing. But like I said, the DOE guidance, the US DOE guidance does authorize the CSC to provide those kind of services. I'm sorry, I didn't really understand. Somebody said CSD. So if you want to clarify the question, that would be helpful.
You were talking about, you said an acronym I don't understand. CSD, CSE?
Oh, I'm sorry. So the CSC is actually the Committee on Special Education. So that is like the people who do the IEP. So the CSC usually includes the school psychologist. It could include the special education teacher. It could include the provider, so maybe the occupational therapist, but I would usually talk to the school psychologist. They were the ones who are usually the ones making the decisions regarding compensatory services and things like that. I apologize. Sometimes I throw these acronyms around and I forget that we should be a little more clear. Can you explain what the LE is and who typically fulfills this role? I'm not really sure what the question is saying there. Maybe I'm not 100% sure what the question is, Jen, but pretty much it could be the school district representative, could be a school psychologist. It could be, I'm sorry, I'm not really understanding the question. I'm not gonna assume what your question is. But if there's any other questions, feel free to send them. Or Jen, if you want to clarify, I'm happy to discuss that with you as well. Oh, okay, I'm sorry, I had missed a question. Would you recommend the parents request an IEP facilitator attend the IEP meeting to encourage the participation of an eligible student? So as a parent, you actually have the ability to, you should notify the school district that when an IEP meeting is happening, that you either want an advocate, you either want someone who has specialized knowledge of that student to attend. So we've had based on my experience, we've had psychologists, we've had counselors outside, private counselors, private psychologists. We've had attorneys ourselves, advocates from our office attend. We've had aunts and uncles who either babysit the child, if it's like, an elementary school student, who come to those meetings to talk about behaviors they've noticed at home. We've had tutors who try to help the student with this particular type of academic, like a reading or writing, attend the IEP meeting to talk a little bit about the student's skills and things that they feel might be important to discuss with the team in terms of either strategies that are helping the student and or strategies that maybe that need to be put in place to help the student. So you as a parent actually have the right to invite people, but you also want to be mindful of HIPAA and confidentiality. Are you comfortable with this person knowing maybe a little bit more about the student than they may know already?
I guess it's my turn to clarify. In the state of Pennsylvania, we have IEP facilitators. They're neutrals that are invited by parents and agreed to by the school district or vice versa that could attend the IEP meetings to be kind of the referee or the neutral at the meeting.
Okay.
That's what I'm suggesting, that an IEP facilitator be invited by the parent or the school district if there's a dispute as to whether or not a student should attend. And that went back to your transition IEP meeting.
Okay, so to be quite honest with you, I haven't really seen an IEP facilitator here in New York. It's not necessary that it doesn't happen, but I haven't really heard of that. But you mentioned the transition meeting. That is very important. Like I mentioned, if the student is higher functioning and they're able to provide input in terms of either, you know, like the vocational assessment where they can talk about what their dreams or what their hopes are of doing after high school, they should definitely be able to attend that meeting. And I'm a little shocked that this is actually happening, that school districts are blocking students from attending these meetings. 3 more messages. Oh, okay. Sorry, I just saw that you're fairly new to New York. Okay, I see that. So like I said, in New York, I haven't really heard of that. Thank you for clarifying. The person who has authority to make decisions and spend school resource dollars, there should always be someone at the IEP meeting who can make such decisions, correct? For example, if you're requesting, yes, so you're correct. Excuse me. So that could be, so the school psychologist and or sometimes we have APs and or it really depends on the situation, right? So a lot of the times when we attend IEP meetings, we have school psychologists or we have like APs, assistant principals or the principals. Sometimes we even have, like when it's a situation where we have a student who's already in an NPS, which is a non-public school, we have people from the CSC office, the CSC chair people or the CSC administrators attending those meetings. So they will be the individual who will ultimately either draft the IEP and or put in the different supports. It can actually be a various number of people. I can't really say it's just a school psychologist because we've seen that it's not always the case. Oh, wow, interesting. Okay, so we actually had a comment in our discussion that unfortunately we did have an individual who was blocked from attending one of their meetings. I'm sorry to hear that. That's a time when either a parent or when a student, but unfortunately a lot of parents don't know about these rights. That might be an opportunity when you find out that a meeting is going to happen and that student is not being allowed. Maybe that's a time to reach out to an advocate and or attorney. I think this is going to be our last, I apologize, last question. Do parents have the right to choose who the service providers are for the child, or do we have to accept who the district offers even if they're not qualified? What to do at the CSC meeting if the district did not implement the IEP and provide services due to disagreement on the provider? So I'm laughing only because I actually had this very situation happen in a case back in December. Unfortunately, in Staten Island, there is a very limited amount of providers for high school students with disabilities. A lot of the providers in Staten Island are actually for CSC, CPSC, CSC, and EI, which is early intervention. So in this kind of a situation, there was definitely a disagreement between the parent, the student, the parent, and the school with regard to providers. The student had high functioning autism and she did not feel comfortable with the various providers at school. So the school district provided RSAs at the DOE rate. And I'm sorry, I'm throwing all these things out quickly. We have 5 minutes and I want to address this question. And RSA is a related services authorization. So the school district did provide that, but unfortunately the parent wasn't able to find a provider who would take that grade. So we actually had to go to an impartial hearing in that case because, you know, we needed the enhanced rate. The school district wasn't able to provide it. We were able to find independent providers who would only take that rate. So we had to go to hearing for that, unfortunately. I hope I answered your question. If not, feel free to message me later. I'm getting so many good questions. I know I said that would be the last one, but I just want to address one more. Do we need to have a CSC meeting first before placing the child in a private school? Okay, so this is actually a very long, complicated question, but I do want to say that I would recommend it because then that would give the school the chance to try to address the things that, you know, you find are lacking in their current program. Additionally, you want to show that you are being transparent, you are cooperating. One thing that I want to tell you is that even if you don't end up having a CSE meeting, you definitely want to provide what's called a 10-day notice. So you have to notify the school district 10 days prior to either signing the contract or the student starting their private placement. I have seen cases where the impartial hearing officer took away tuition or said that tuition reimbursement wasn't allowed because the parent failed to notify the school district regarding the private placement enrollment and things like that. There is a recording. There probably will be a recording of today's session, Constance. I'm not really sure where it'll be on our website. So feel free to email me and then we can send you a link. I can talk to the marketing team about that. But if there's any particular questions that you want to talk to me about, like I said, our email, my email is apal@littmancrooks.com, and my phone number 914-684-2100. I hope you guys enjoyed today's discussion as much as I did. And next week is also a very important one for individuals with disabilities, students who are transitioning out of high school and or, you know, things like that. It's a discussion by my colleague, my good friend, Stephanie Goldstein. She's going to be talking about advanced directives for the college age student, or I should say, you know, an individual with maybe a student who has a disability, but they need supportive decision making and things like that. So please join us next week, Tuesday, same time, same place. We hope to see you there. Have a great day and be safe, everyone.